Everyone. I'm Nadine White-Boyd, and I have the pleasure of presenting today the Garnishment and Bankruptcy seminar to our community. Thank you for being here, and thank you for the time that you're going to spend. If you have any questions while I'm doing the presentation, you can put it in the chat, and we will address your questions. Again, I'm Nadine White-Boyd, and I'm with the White-Boyd Law Firm, which is based here in Palm Beach County. I've been doing bankruptcies for a little under 30 years, and I handle both debtor and creditor matters, individuals and businesses, as well as representing bankruptcy trustees. In addition to bankruptcy, I also handle real estate matters, corporate transactions, and estate planning matters. So again, thank you for being here, and without further ado, I will get started. So you signed up to attend this seminar because you wanted to hear about garnishment and bankruptcy and how to avoid bankruptcy. So today we'll be covering garnishment, what it is, how you can avoid it, what happens in a garnishment proceeding, also the types of bankruptcy and bankruptcy myths, determining which type of bankruptcy to file if you determine that bankruptcy is a necessary option, and what to expect after you filed for bankruptcy, what the creditors can do after bankruptcy is filed, and what you can do after a bankruptcy is filed. So the goal here is to, there's debts on your back, and to unload those debts from your back in the event of a garnishment or any other type of collection activity. A lot of what we'll discuss this afternoon will also apply to other collection activities, but our focus here today is on garnishments. So what is garnishment? And so the easy thing is to go to the dictionary's definition. Wikipedia defines it as, just like it's spelled out here, it's a legal process for collecting a monetary judgment on behalf of a plaintiff from a defendant. Garnishment allows the plaintiff to take the money or property of the debtor from the person or institution that holds that property. Who is a plaintiff? A plaintiff, it's, for example, the person or a company that is suing the person who owes them a debt. So, for example, a credit card company would be the plaintiff, and if you owe the credit card company, you would be the defendant. And once a judgment has been entered in the plaintiff's favor, then the garnishment proceeding begins. The garnishment proceeding does not begin prior to a judgment being entered. And you'll hear me say that again throughout this presentation. Merriam-Webster's dictionary defines it as a legal summons or warning concerning the attachment of property to satisfy a debt. So essentially, it's a legal summons, meaning that once a judgment has been entered, the plaintiff, now called the judgment creditor, will need to initiate a legal summons, a writ of garnishment, in order to go after your property, the defendant's property. It is a stoppage of a specified sum from wages to satisfy a creditor or a legal obligation, such as child support, or like I said before, a judgment. So it stops the specified sum from someone's wages. So a garnishment, like it says here, it's a garnishment. They're trying to go after someone's wages. Okay. So a garnishment occurs after entry of judgment. Okay. So first, like I said before, a judgment has to have been entered. Now, the key here is that judgments in the state of Florida last for 20 years. So that means if a judgment has been entered against a defendant, the judgment creditor, plaintiff, can proceed and go after the debtor, the judgment debtor, the defendant for 20 years. They can try to find what's under the mattress, what's in the bank account, just your wages, your vehicles. They can go after assets that you have. They can bring you in to do depositions, anything that is going to give them the opportunity to be able to find out what you have, what type of assets the defendant has. So if you get a lawsuit, you want to be careful and know that if the judgment is entered against you, That means a judgment will last for 20 years. Assets that can be garnished with some exceptions, which we'll talk about. Assets that can be garnished include someone's wages. So if you're employed, they can go after your wages. That is, the judgment creditor can go after the wages. Bank account. If someone has a bank account, they can go after your bank account. They can, a tax refund can be levied by the IRS. So the IRS can garnish someone's tax refund. They essentially levy on it. You're supposed to get a tax refund. You owe that. They can come after that tax refund. Once a judgment has been entered, it becomes a lien on property that you own. For example, your home and a vehicle, which means if you then try to sell your home, or if they put a lien on your vehicle, that means you would have to pay that debt. Or you may be in a position where you're not able to pay the debt because your home, you do not have enough money to be able to pay off a loan, if there's a loan on the home, as well as the debt of the judgment. Bear in mind that only the judgment debtor is responsible for the debt, and only their property can be garnished to satisfy the debt. What exactly does that mean? That means in the event you're married, you're husband and wife, and a judgment is entered against the wife, and only the wife, the husband is not responsible for that debt. We see that, for example, in medical actions. So, for example, someone owes a doctor and the doctor is not paid, but the wife did not sign and is not responsible. So the doctor's office sues the husband. Well, they cannot go after the wife. Okay, so it's only the judge, only the person who's responsible who is sued, and then they're the judgment debtor, and then that person will be the only person responsible for the debt. And we'll talk about what happens if you have a joint bank account and the judgment creditor tries to go after the joint bank account, but only the husband is responsible for the debt. In a nutshell, they cannot do so. That is, the judgment creditor cannot do so. So how do you know when a garnishment action is filed against you? It would be nice if they knocked on your door and told you, hey, we're going to garnish your bank account, or we're going to garnish your wages, or we're going to, come after whatever other assets you may have. Well, it's not that easy, unfortunately. So how you normally find out is all of a sudden money has disappeared from your bank account. And I have here disappeared in quote because it technically has not disappeared. It means that they essentially has frozen your bank account and you cannot access those money in your bank account. So for example, someone gets a judgment against them. They have no idea, they're going on with their life. And 5 years ago, they got this judgment against them. They're working and they're doing everything as normal. And they had $5,000 in Wells Fargo bank account, and they go to take out $300 and there is nothing there. Okay. And that's when they'll find out. They go inside the bank and they say, what happened to my account? Why, I had $5,000. Well, the bank will say, sorry, we received what's called a writ of garnishment. Okay. Another thing is you go and get your paycheck. It's Friday afternoon. You're looking forward to your long weekend. You get your paycheck, either in person or it gets deposited into your account. And instead of it being $2,000 deposited into your account, only $500, or only, well, not $2,000, maybe $1,000 gets deposited in your account. You say, what happened? Well, your paycheck has been garnished. So those are some of the situations where you will then find out that a garnishment action is filed against you. Let's say none of those happen. You don't have a bank account. You don't have a job, a regular job, but instead you receive in the mail what's called a writ of garnishment with claim of exemption. And the writ of garnishment may have your name. So let's say, for example, the judgment creditor is Wells Fargo Bank. And let's say Tom Jones is the judgment debtor, and they believe Tom Jones has a bank account at Bank of America, they will have issued a writ of garnishment on Bank of America. And then about a few weeks after they've issued that on Bank of America, you will receive in the mail a writ of garnishment, not you, but the judgment debtor will receive in the mail a writ of garnishment with claim of exemption, okay? And that writ of garnishment enables the judgment creditor to intercept money owed to the judgment debtor, which is owed to the judgment debtor by Bank of America, by third parties, okay? So at that point, if the judgment debtor had monies in Bank of America must freeze the account. But if they have no monies there, they'll still receive the writ of garnishment with claim of exemption, but the judgment debtor will say, I have no money in there, so I don't really care, okay? But essentially, you may still want to take some action as far as, deciding, do I want to try to settle? Because now you see that the judgment creditor is trying to find out where they can get your assets. The judgment creditor, like I said, is the plaintiff. That's the person or company that filed a lawsuit against the person who owes the money and was awarded a judgment by the court. The judgment debtor is the person who owes the money to the judgment creditor. Do we have any questions? No. What should you do when you receive a writ of garnishment? First of all, do not ignore it. Okay, now I just use an example where I said Bank of America may not have any funds, or there's no bank account for the individual, the judgment debtor. And so, well, maybe you just ignore it at that point because there's nothing. But in terms of that writ of garnishment, if you ignore it, it's not going to be to your detriment. But when we say do not ignore it, it means that you may want to consider contacting an attorney immediately. Okay, and at the end of our presentation, there's a list of resources of different agencies that have pro bono attorneys that may be able to help you, for example, legal aid, of course. Okay, also, if you receive a writ of garnishment and they are garnishing your wages or a bank account, if you qualify to exempt the asset that is being garnished, you must immediately file a claim of exemption. You have 20 days within which to file a claim of exemption and have a hearing before the court. So the court will set a hearing date so that you can come to court and make your argument and provide the evidence as to why the funds that's being garnished or the account or your wages that's being garnished should not be garnished. So again, do not ignore a garnishment, a writ of garnishment that is received. What assets can you claim exempt from garnishment? So luckily, we're able to claim some assets exempt from garnishment. So you can avoid garnishment, but if you ignore that writ of garnishment with the claim of exemption that comes in, you may be in a position where you're unfortunately not able to protect your asset that you otherwise would have been able to protect, okay? So a judgment debtor may file a claim of exemption as to wages. Okay? Wage garnishment exemptions are a form of wage protection that prevents the garnishing creditor from taking certain kinds of income or more than a certain amount of your wage. So if you are head of household, you have a judgment entered against you, you receive a writ of garnishment because there was a judgment entered against you, you can claim on that claim of exemption form that you're head of household and the income is exempt. Also, if a person makes $750 or less per week in net wages and the person is head of family, those wages are exempt from collection. A head of family is a person who provides more than 1/2 of the support for a child or other person. Wages in a bank account that belong to a head of family retain their protection from being seized for 6 months, even if the wages are mixed with money from other sources. So again, it's important to seek out an attorney and contact an attorney, speak with an attorney. Do not simply ignore the claim of exemption, the writ of garnishment. Otherwise, you will continue to be garnished. Again, what assets can you claim exempt from garnishment? We have several types of debtors' assets can be claimed exempt from a writ of garnishment. Exemption to garnishment of a bank account holding Social Security proceeds. So if it's someone's Social Security proceeds, that's exempt. Okay, Social Security proceeds. We have workers' compensation, unemployment benefits, disability benefits, veterans benefits, retirement benefits. Those are all exempt from garnishment. So if you're a person who is a veteran, you're elderly and all you receive is Social Security, you're unemployed and all the money's in your bank account is for your unemployment benefits, or you're disabled and it's all for disability benefits. Again, you're entitled to file a claim of exemption and have a hearing and essentially have your funds returned to you. But if you do nothing, you're losing that opportunity. So again, contact an attorney. Spousal exemptions from jointly held property. As I said before, in the event that the judgment debtor is one spouse, the other spouse is not responsible for the debt, you can claim spousal exemption because maybe all the funds that are in the account belongs to the non-judgment debtor. Okay, that's the debtor who the judgment was not entered against, the spouse who the judgment was not entered against. So it's really important, again, that you pay attention to this, you check the mail, you know what's going on. Obviously, if your account is frozen, I think that will be very alarming and that will, trigger you to see an attorney. What other assets can you claim exempt from garnishment? So Florida statute allows you also to claim other assets exempt, okay? So for example, a debtor's interest not to exceed $1,000 in value in a motor vehicle, okay, as defined in section 320.01. So that includes a motor vehicle, it may be a motor home, things of that nature that falls as a motor vehicle. Now it's a single motor vehicle, okay? So if a judgment debtor has two vehicles, okay, your husband and wife, and you have two vehicles, but both vehicles is in the name of the judgment debtor, unfortunately, it's $1,000. Okay, it's not $1,000 per vehicle, it's $1,000 and that's it, unfortunately. However, if the vehicle has a lien, so you're making payments, maybe there is no value in the vehicle, although these days vehicles are going up and the value of the vehicle are holding steady and more than we normally see. So there may be some value, but typically, if there's no value in the vehicle, then it doesn't matter if it's $1,000 because you don't have value. And so a judgment creditor does not want that. Even if they try to come after your vehicle, they don't want a vehicle that essentially already has a lien on that vehicle, okay? But if your vehicle is owned free and clear, you're driving it around, you may think, well, it's only worth, $3,000. Well, they may still take that vehicle and sell it and give you $1,000, and then they keep that, the other $2,000. So again, make sure you're protecting yourself, but at the same time, you can only protect it up to $1,000. A debtor's interest in any professionally prescribed health aid for the debtor or a dependent of the debtor. So for example, if you use any devices, hearing devices, seeing devices, your handicap chair, anything like that, those are protected. So they cannot sell those personal assets, okay? Because we only are allowed $1,000 in personal property, similar to the vehicle. A debtor's interest in a refund or a credit received or to be received, or the traceable deposits in a financial institution. That's what we call earned income credit, okay? That's also exempt. A debtor's interest in personal property not to exceed $4,000. But you're only allowed to protect up to $4,000 if you do not have a homestead. Okay? So if you have an asset, let's say a vehicle, for example, you have this vehicle here, but it's all paid off, it's worth $10,000. You know, you're driving around, it's not in the best shape, but you get to use it, right? But unfortunately, you now have a situation where you have a judgment against you. You can claim $1,000 in the vehicle. You can use another $4,000 if you do not have a homestead. You only get this if you have a homestead, but it protects the vehicle up to $5,000. So therefore, if it's worth $10,000, unfortunately, again, the creditor can take that vehicle, sell that vehicle. You claim exemption that you're allowed to keep $1,000 plus $4,000 if you do not have a homestead. Okay. Okay, how do we avoid garnishment? How do we deal with debts and judgment? Debt before, judgments, garnishment, and debts before a judgment is entered. Okay, so if a lawsuit has been filed, but a judgment has not yet been entered, how do we deal with that? If a judgment has not been entered against the judgment debtor, against the defendant, the creditor cannot take garnishment action. Garnishment action is only applicable after entry of a judgment. Okay, so that's the key. So if someone is garnishing your account and they never obtained a judgment, then something is terribly wrong. Someone is not paying attention, that the employer is not paying attention or the bank is not paying attention, but essentially a garnishment will not occur before, or you do not need to worry about, you get a lawsuit filed against you, you do not need to worry and think, oh my goodness, my bank account is going to be garnished or my paycheck is going to be garnished. Okay, it only takes effect after a judgment has been entered. Again, however, you need to make sure that you're contacting an attorney to find out, hey, I received this lawsuit, because you don't want it to become a situation where a judgment is then entered against you. So can you dismiss that lawsuit once it's been filed? So certain things you're going to look at, but again, you know, these are just things for you to be aware. So you get a lawsuit from, this is one thing I hear a lot of in my office. Someone will walk in and they say, well, I had a judgment against me, but it's not me. It's, you know, or I don't even know about this credit card. And it is about, you know, 10 years ago, I might have had this credit card. And I said, well, do you remember being sued? Yes, I was sued, but I did nothing because it wasn't me, or it was such a long time ago. And I was told that, oh, if it's over 5 years, it doesn't matter. Well, again, you get a lawsuit, you need to pay attention. You need to call an attorney's office. You need to contact legal aid. Okay, so do not simply ignore it, because you may be able to dismiss that lawsuit. Okay, so that's one way of avoiding a possible garnishment. If you're able to dismiss that lawsuit because the time within which they are required to file the lawsuit has expired, then you can dismiss the case. Okay, they can continue to call you, they continue to try to get money from you, but they cannot they cannot get a judgment against you if you dismiss the case. But if you do not, then they will still have a judgment against you, and now the judgment lasts for 20 years. Okay, so if you want to dismiss the lawsuit, for example, because the time, this was 10 years ago, you haven't used that credit card, or maybe it's a doctor's office, you hadn't visited the doctor's office, or maybe it's a friend who you loaned money to and you were supposed to pay them back, but it's been, you know, 10 years, essentially, you get to dismiss those lawsuits. Okay, so one of the ways you can dismiss a lawsuit is statute of limitations. Okay, and like I said here, creditor has 5 years to file a lawsuit for breach of contract pursuant to Florida statute 9511(2)(b). And if they fail to timely file, then the debtor can file a motion to dismiss. Also, can the lawsuit be dismissed? If you believe that you are not, you know, maybe you have a common name, your name is John Smith, okay, and they file a lawsuit against you, and you said, this is not me, I never had it, I never had this account. I never even lived at this address. I can show all the addresses where I've lived. This is not me. They just are suing the wrong person. Again, do not simply ignore it. Contact an attorney and see what would be, if you have the option of dismissing it, okay? At minimum, even go to the courthouse and file an action, okay? There's the help desk at the courthouse. You file and get a motion to dismiss, and you dismiss that action against you, okay? But at the end of the day, do not ignore the lawsuit, okay? That's how you'll avoid a garnishment, because if you ignore the lawsuit, you get a judgment and potentially a garnishment that you can have for 20 years. How do you deal with debts? Again, before garnishment and judgment. So let's say a lawsuit has been filed, a judgment has not yet been entered, but you have no defense. You know that you're the one who essentially used this credit card, or you're the one that has these doctor bills, or you're the one who, were in a car accident and, the other vehicle was damaged and you were sued by the insurance company, whatever. Essentially, you can reach out to them and negotiate, and negotiate resolution so that you do not have a garnishment entered against you, okay? And it's best to negotiate a settlement before the judgment is entered. Because if you wait until after a judgment is entered, and if you have a job, or you're a young person who's trying to build your credit, these will put you in a position where now they may not want to settle with you, okay? A judgment doesn't mean that the judgment creditor will not settle, but essentially you're just putting yourself in a position where now they have all the cards are in their favor and against you. So now you want to try to settle it before a judgment is entered. So you can try to do different types of settlement in order to avoid the garnishment. You can try to do a lump sum settlement for a reduced amount. Okay, so a lot of times creditors will be more inclined if you're going to pay them everything up front, if you have the ability to do so. For example, I get a call from someone the other day. It was, her son had owed $3,000. I mean, not a lot of money in the big scheme of things, but a lot of money for a young person. So $3,000 he owed, and the mom wanted to try to pay the debt for him, but she tried to settle it, for a reasonable amount that she'd be able to pay all in one lump sum so that he wouldn't have to pay. They agreed that he could pay the entire thing at $137 per month for however many months that would last. But again, mom says, I'll try to settle it. Mom tried to settle it for a reduced amount, okay? Sometimes they can get it settled for 50 cents on the dollar, 50%, or you may be able to get it for 20%, okay? If you provide them with information that you have no resources, no monies. But however, in that case, the mom said they offered her 70%, so she would have to pay 70% in a lump sum, which she did. But it still was, like I said, not a large amount in the big scheme of things, so she was able to pay that. Sometimes we're talking about tens of thousands of dollars, and people are not able to pay such a large amount in a lump sum settlement. But if you can, then, and you have no defense, and you're a young person and you're going on with life, and you may decide, I'm going to try to settle this, okay? So you avoid the garnishment by doing a lump sum settlement, or you can do an installment payment plan. Again, if you're going to do that, you call them up, you call the attorney up who represents the plaintiff, contact them, let them know that you're trying to settle this debt, and you can do a payment plan, and here's the payment plan that you will do. But again, do not enter into an agreement that you cannot comply with, okay? Only do this if you're able to comply. Also, there may be situations where you don't want to. So I use the example of a young person who is going to have a job, and if a judgment is entered against them, the likelihood is they'll be able to garnish their wages. But let's say you are an elderly person, and all you receive Social Security income, or maybe you have no income or disability income that is exempt from garnishment. You may decide that You do not have the financial resources to settle. Even on an installment plan, you have such minimal income, you may decide, I'm not going to settle, because even if they get a judgment, I am old, I'm 80 years old, what are they going to do? I'm not saying that you just let it go, but you essentially consider, do you need to actually settle with this creditor if you do not have the financial resources to settle? Okay, we don't want to put you in a position where you'd be in a worse position by trying to settle something that you cannot afford to settle. Okay, even on an installment plan. So how do you avoid judgment? Avoid garnishment after entry of judgment? Again, judgment lasts for 20 years. After a judgment, they can try to do discovery. Discovery means they call you in to, answer questions. And when I say they call you, they set up what's called a deposition. They want to depose you to find out where your assets are. Okay, what houses you bought, what cars you have, what monies you have, where's your bank account? Okay, so they can keep doing that. Okay, so again, after entry of a judgment, as I indicated, you don't want to wait till a judgment has been entered, but if a judgment has been entered, you want to do a similar exercise that you would have done prior to entry of judgment. Negotiate settlement. Okay, so that means, again, you do a lump sum settlement for reduced amount or installment payment plan for reduced amount. And like we say here, confirm everything in writing. Okay, also request that the case be dismissed. You want to make sure that that case is dismissed. It's not, the judgment is already there. And once you've paid it, you also want to make sure you receive a satisfaction and release of that judgment. Okay, and so if you do not have an attorney, or even if you have an attorney, you want to make sure that you are on top of this, because these will be, if you get a settlement and you forgot to receive a release and satisfaction of the judgment, years may go by and all of a sudden you're trying to get a credit to, now you're trying to buy a home, and you find out that that judgment was not released, and you're trying to find the attorneys that were involved, you can't find them, and it just becomes a headache. Okay, it's almost like the debt is still on your back, weighing you down and not allowing you to be able to move on with life. Okay, but the whole goal of trying to settle these judgments before entry of judgment is so that you don't get a garnishment. So don't wait until after a judgment is entered. Another way to avoid garnishment is to file for bankruptcy. Okay. Bankruptcy is governed by Title 11 of the United States Code. And what bankruptcy does, it allows the debtor to get a fresh start. You've heard this word before, debtor. I say judgment debtor. And in bankruptcy, we have the same word, debtor. That's the person who files for bankruptcy, or the company that files for bankruptcy. Today, we're just talking about individuals. We're not addressing companies, but if you have a company that needs to file for bankruptcy, they're also called the debtor. They're not called a judgment debtor. They're simply called a debtor, and they file bankruptcy to get a discharge and to get a fresh start. So those are good words in bankruptcy world. Okay. There are different types of bankruptcy that you can use to avoid garnishment. Okay. We have chapter 7, 11, 12, 13, and 15. Okay. Chapter 7 is a liquidation. And we'll go a little bit more into that, how you get rid of garnishment in that, or any type of collection activity. So when we talk about bankruptcy here, it pretty much avoids any type of collection activity, including a garnishment. Okay. Chapter 13 is a reorganization for individuals with income. And the key here is that they must have income. Chapter 11 is for reorganization, similar to chapter 13. Chapter 12, it's for family farmers. and chapter 15 is for foreign bankruptcy. So we're not going to be talking about 12 or 15, but a lot of what we talk about with chapter 7, 13, and 11 applies with respect to garnishment and any other type of collection activities. Okay, so if someone trying to attach your car, for example, repossess your car, for example, it applies in those situations as well. Before we go into what bankruptcy, how to avoid collection activity and garnishments, we have what are some bankruptcy myths. So a lot of people always talk about, you know, I don't want to file bankruptcy. Bankruptcy is a bad thing. We shouldn't be doing bankruptcy. But bankruptcy, there's a lot of myths about it, and I try to clear up some of those myths today. You'll never be able to buy a home or a car. That is absolutely not true. You may not be able to buy a home or a car if you do not have income. So you file bankruptcy to stop collection activities. The goal is not for the bankruptcy system to cause you not to be able to be to do things such as buy a home or a car. The goal is for you to get a fresh start so you will be able to buy a home or a car. So put those garnishment, those collection activities behind you. Also, that another myth is you'll have bad credit. Actually, you have no credit, okay? And what that means is that it's similar to when you never had credit. You didn't have a credit card, you didn't have a job, but it's not bad credit. It's just simply no credit. And just so you understand, while you're in bankruptcy, particularly chapter 13, you can purchase a home, you can purchase a car, you have to get the court's permission, but you can do that even though you do not have credit. So you will not have bad credit during bankruptcy, you simply have no credit. You will start building your credit at the end of the bankruptcy. So in a chapter 7 situation, which lasts about 90 days, you will begin to have credit. In a chapter 13 situation, at the end of your chapter 13, whether it's a chapter 13 lasts for as long as 5 years, but if you're in it for only 3 years, you start building your credit after those 3 years. You'll never have credit. A lot of people say, well, I'm not filing bankruptcy because I'll never have credit, and now it goes back to I'll never be able to buy a home or a car. That is not true. You will have credit. For some, it will take a little bit longer, okay? But for others, maybe you have a house that you're paying on, a car that you are paying on, and so that's how you're going to start building your credit, okay? Just like when you first started out in life and got that first job and got that first credit card, and that's how you start to build credit. You cannot get rid of or discharge medical debts. There are a lot of people coming into my office saying, well, I have a lot of medical bills and, you know, I don't have credit card debts, but I'm told that I can't get rid of my medical debts in bankruptcy. That's not true. You can get rid of medical debts in bankruptcy, okay? For some people, that is the reason why they're ending up in bankruptcy, because they had unfortunate situation. Okay, they're ill, they're going through cancer treatment now with COVID. You're in and out of the hospital, you didn't have insurance, and so you have medical bills. You can get rid of those medical debts. You cannot get rid of or discharge IRS debts. That is also a myth. It's true to some extent that you cannot get rid of IRS debt, because it really depends on how old the IRS debt is, okay, and whether you timely filed your income tax return. So if you did everything, you've timely filed your income tax return, and the IRS debt is older than 3 years, you can get rid of it if the IRS did not file a lien, okay, they did not record that debt. So there are some situations where you can get rid of the IRS debt. Another myth, you will lose everything that you own. That is not true, okay? If you want to keep assets, that's why we have chapter 13 and chapter 11. You get to keep your assets. Chapter 7, you may lose your assets. And sometimes people are willing to file a Chapter 7 because they look at it in terms of, for example, you have an account, you have a judgment against you, you're going to be garnished, and you qualify to file for Chapter 7 bankruptcy. So instead of being garnished, you file Chapter 7, and you may say, well, I have some assets here that, maybe I have $10,000 in the bank, but this garnishment is for $50,000. And you weigh the pros and cons of filing Chapter 7 versus Chapter 13. Chapter 13, you would have gotten to keep that $10,000. In Chapter 7, you would lose if you don't have a home, you could lose maybe $5,000 off that $10,000, depending on what else you have. But if you have only $10,000 in personal property, and you say, well, gee, if I file bankruptcy, Chapter 7, I lose that $10,000, but it's over with in 90 days. Okay, so you potentially will lose what you own, but you weigh the pros and cons and say, well, I only have 10,000, but I'm getting rid of $50,000 of debt. Okay, I'm no longer being garnished. They can't drag me in to get me to go to a deposition or to produce my bank statements or garnish my wages. So in that case, it may be beneficial to file bankruptcy. So again, it's just a myth that you lose everything. You get to keep depending on the type of bankruptcy that you file. So if the person files for Chapter 13, they will be able to keep their assets. You're only allowed to file for bankruptcy once. That is, again, a myth. You can file for bankruptcy more than once. There are some exceptions to you filing for bankruptcy and being able to protect certain assets if you file for bankruptcy more than once. So for example, if you're in foreclosure, you have a home, you need to file bankruptcy, you filed bankruptcy, and then the case got dismissed for one reason or another. Then 6 months later, you decide you want to file bankruptcy again. Or 3 months later, let's say you decide you wanted to file bankruptcy again to protect that home. In order to make sure that you can file the bankruptcy, but in order to protect that home, we have to file certain action within the bankruptcy case. Okay, so generally, you are allowed to file for bankruptcy more than once, more than twice, more than 3 times. Okay, not back to back. All your debts are discharged. Okay, that's a myth. All your debts are not discharged. Okay, so things such as student loans may not be discharged. Things such as domestic support obligation. Things such as child support. Okay, things such as a debt that was incurred as a result of criminal activity may not be discharged. Okay, debts that you obtained by fraud. So if you perpetuated fraud on someone to get a loan, they can file a lawsuit against you in bankruptcy and not have their debt discharged. Okay, so again, just like I've been saying throughout this, if you're going to file bankruptcy, it's best to contact an attorney. There are bankruptcy petition preparers, but it's best to contact an attorney. Okay. And again, bankruptcy does allow you to protect you from garnishment and collection activities. So this is another way to avoid garnishment. Okay, what happens after you file a bankruptcy? So immediately upon filing a bankruptcy, we have what's called the automatic stay. So that's how, if you are being garnished immediately upon filing the bankruptcy, the automatic stay goes into effect and the garnishment must stop. Okay. Also, if monies were garnished within 90 days before the filing of the bankruptcy, those funds must be returned. So what will happen is, if you have an attorney, the attorney sends a nice little letter out to whether it's, whoever the judgment creditor is and whatever the bank is that may have it, or the employer who may have frozen and not paid you your salary. they'll send a nice letter out saying this person filed for bankruptcy and please return the funds. Okay, that was garnished. So sometimes, you know, you have no intention of filing bankruptcy, but you have a judgment against you, and then you realize, oh my goodness, I have a judgment. What do I do? They're garnishing my account. You may decide, I don't want to file bankruptcy. I'll take my chances. And while you take your chances, well, your bank account is garnished. But if you filed a bankruptcy within 90 days, okay, then those funds must be returned. Now, if it's a Chapter 7, depending on how much funds it is, you may or may not get it back yourself. It may go to the creditors, but again, that all comes into play as to why it's necessary to have an attorney determine which bankruptcy is best. When and where does that money go? That money goes into the bankruptcy estate, because immediately when a bankruptcy is filed, a bankruptcy estate is also created. Okay, and the bankruptcy estate includes all legal equitable interest of the debtor in property at the time of the bankruptcy filing. So this garnished funds that comes back into the estate, that comes back into the bankruptcy, it goes into the estate. Okay. The estate includes all property in which the debtor has an interest, even if it is owned or held by another person. So that's where now those funds are held by the bank, for example. Okay, it still goes into the bankruptcy estate. Okay, your employer has those funds, it's garnished, it goes back into the estate. Okay. Do we have any questions, Takesha? No questions. Okay.
Not yet.
Okay. What assets are you allowed to keep in bankruptcy? Okay, similar to in the non-bankruptcy world, where you're allowed to keep certain assets, in a bankruptcy world, you're also allowed to keep certain assets. And that's why I said earlier, you do get to keep some things in bankruptcy. Okay. So we have what's called, first, most people know about the homestead exemption in Florida if they own a home. So they own a home, they get to keep that home with some exception. It cannot be larger than half an acre if it's in a municipality, or if it's outside the municipality, 160 acres. Okay. In bankruptcy, the homestead property, if it's obtained within 1,215 days before filing the bankruptcy, it gets full exemption. So what does that mean? Someone files bankruptcy today, August 18th. Well, before they file, we go back and we look and determine, okay, how long ago did this person file the bankruptcy, purchase the property? Okay, the homestead. If you purchased it within 1,215 days, then we have to get to another layer to say, is there equity over $189,050? Okay, if it is, if there's equity over that amount, you may not be able to keep it in bankruptcy if you filed, for example, a Chapter 7. In a Chapter 13, a Chapter 11, a Chapter 12, a Chapter 15, you would be allowed to keep it. Okay, so again, it's key to know, because you don't want to file a bankruptcy to avoid a garnishment or avoid another collection activity and then put yourself in a situation where you're potentially losing your home. However, again, you can file for Chapter 13. Okay, Chapter 13 or 11 will allow you to keep that home, but there are you would have to, what we call, pay back some of those funds in the bankruptcy. Okay, and this number that I just referred to is for the period from April of sorry, let's go back. April 1st of 2022 through March 31st of 2025. Okay, this number changes every 3 years. What other assets are you allowed to keep in bankruptcy? So even though your account is now being garnished, you filed for bankruptcy, again, you do get to keep some assets in bankruptcy, not all, but some assets. So we talked about the motor vehicle under Florida statute. Even though bankruptcy is federal law, we apply the Florida statute, we get $1,000 for motor vehicle, we get $1,000 for personal property. and we allowed another $4,000 if the debtor, the person filing bankruptcy, does not claim a homestead exemption under Article 10, Section 4 of the Florida Constitution. Okay, if they claim it, that they have a homestead, they do not get to keep personal property, an additional $4,000 in personal property. You do not get to keep that. Okay. So now that we've gone through, what happens immediately, and the fact that it stops collection activity and you avoid garnishment in bankruptcy, okay, and what assets you get to keep, well, you have to determine what type of bankruptcy to file. And should you file for Chapter 7 bankruptcy relief, that is liquidation, okay? And like liquidation, it really says that's pretty much you're liquidating all your assets in a Chapter 7, which is why it's best if someone is filing a Chapter 7 that they have little or no property. And when we say property here, we mean real property, whether it's a vacant lot somewhere, whether it's a timeshare, not your homestead property with that exception that we talked about before. Okay, so again, you file Chapter 7, but you may want to have little or no assets, because otherwise in a Chapter 7, those assets may be liquidated, means sold, goes to auction, and then they take the funds and you do not receive the funds, with the exception of the property that you're allowed to keep, which we just discussed, $1,000 and the $4,000, or the motor vehicle $1,000. Other things you do get to keep, by the way, in bankruptcy, if you have a IRA, okay, so you invest, you have a 401k with your job, you have life insurance, you have a Roth IRA, you have a simple IRA. Those things are protected in bankruptcy. Okay, so you do get to keep your 401k, you do get to keep your Roth if you have one, you do get to keep your life insurance. However, do not have a lot of money in your bank account and then decide to dump it into your 401k or dump it into your Roth IRA, because they may be still able to get those depending on the timing. You cannot move assets, okay? That would be fraud. Okay. Also, who files a Chapter 7? Someone with little or no income. Now, remember when we talked about the garnishment, I said there may be a time when someone is elderly and they may decide not to do anything. But a lot of times someone who's elderly, the stress of a debt collector calling them each and every day, they don't have the financial resources to settle a debt. Now a lawsuit has been filed, they may determine that they want to file for bankruptcy because they have little or no income. Okay, they have no assets. So even though they mean the judgment creditor is not able to take the Social Security that you have, you may still decide that you want to file bankruptcy because they have nothing to garnish. You don't need to file bankruptcy, but the stress is more. It's more of a burden on your back that you cannot handle, and you may still decide you want to file for bankruptcy. As I said, Chapter 7 debtors may lose some property. That is, they may have to walk away from some assets, or you may be allowed to buy it back. Those are some assets, such as, like I said, if you have a car that's worth $10,000 and you claim $5,000 of it exempt, you can pay what's called the bankruptcy trustee. That's who's appointed when a bankruptcy case is filed. Pay the bankruptcy trustee $5,000 and get to keep the car. Okay, so that's what we mean when we say buy back non-exempt assets. Okay, determining again which type of bankruptcy to file. Chapter 13 requires a debtor to make payments in a plan anywhere from 3 to 5 years. Okay. Now, you may be in a Chapter 13 for less than 3 to 5 years, but that is the required time period for you to be in a bankruptcy. And so there's certain situations where someone may end up being in a bankruptcy for less than 3 years, but this is essentially the period of time that someone needs to be in a bankruptcy. Okay, we're not going to go into the basis. If you have a question, you can ask me that, but the basis for when is it 3 years, when is it 4 years, when is it 5 years, when can it be 1 year? Okay, that's what you'll consult with an attorney and they'll be able to tell you, is it a 3 years, is it 2 years, is it 1 year? But you're typically required to be in it for anywhere from 3 to 5 years. Chapter 13 is for individuals with wages. Why do you need to have wages? Because essentially you need to make payments. Like I said here, you need to make payments for up to 3 to 5 years. Now, if you have no income, no source of income, then essentially you cannot be in a chapter 13 because it would not be feasible for you to make payments if you have no income. But the wages does not include income necessarily only from a job. It could be that you're getting contribution from third parties. Maybe someone lives in the home, they pay rent. Okay, maybe your family gives you money once a month. So that's another form of income. Social Security. Social Security in one situation in bankruptcy is not considered income, but for the purpose of making your plan payment is considered income. Okay. You have disability income. That's considered income as well. Pension. That's considered income. If you have a spouse and they're not filing bankruptcy, their income can be included as well. Okay. If you get, any type of retirement benefits, that's considered income. If you get, if you have, let's say you at one time were an insurance agent and you get residual income, that would be considered income as well. If you have a business that you get income from, any source of income, any source of monies that's coming into you monthly, that's considered income. Okay, so someone who doesn't, if you're self-employed, obviously that's income as well. Okay, so you need to have some source of income in order to file Chapter 13. So we have to decide which type and why would we want to file for Chapter 13 as opposed to Chapter 7, which is finished in 90 days. Essentially, you may do things like save your home in a Chapter 13. So it's not only about the wages that are being garnished or the bank account that's being garnished or the, the collection activity that is happening with respect to why you want to file bankruptcy. There may be other reasons as well that someone who's being garnished says, you know what, yes, I could walk away and not do anything and try to settle this debt and not be garnished anymore. However, by consulting with an attorney, you'll find out, oh, well, maybe I can file bankruptcy Chapter 13 in order to save my home. And I'll also be only having to pay a percentage of the debt. So how do we determine whether Chapter 13 may be beneficial in addition to getting rid of the garnishment and avoiding the garnishment? Well, it allows you to pay a portion of the debt owed to creditors in a Chapter 13. What that means is you're not paying the full amount of the debt. In some situations, you may have to pay 100%, but at minimum, you're not incurring any interest, okay? If you have a student loan debt, you may be able to do a payment plan in your bankruptcy Chapter 13. If you owe taxes, like I said before, taxes can be discharged, but if it's one where you cannot discharge it, you can pay it back and you can have up to 5 years to pay back those taxes, okay? Are you behind in your car payments? Or is the car payment so high that you cannot make those car payments? Well, you can actually modify that loan, okay? And on the car payments, meaning that if your payments end in 3 years, but you're in a bankruptcy for 5 years, you may be able to stretch it out over 5 years. Okay, so that $10,000 that you owe that is coming due in 3 years, you can stretch it out over a longer period of time. Or maybe you want to give back the vehicle and not have the burden of a deficiency when they sell that vehicle. So you say, okay, I file it. Not only am I paying back that judgment that I have, okay, but I'm also being able to modify my loan on my car, or I may surrender the vehicle. I may decide that I don't want to keep that vehicle anymore. I surrender the vehicle, you surrender the vehicle as well. You can also save your home. So in the event that you're behind in mortgage payment, so you have judgment creditors coming after you, your accounts are being garnished, and you're trying to, what do they say, rob Peter to pay Paul, you're still using credit cards, but you say, wait a minute, if I were to file bankruptcy, I'm getting rid of those collection activities, I'm able to save my home because I'm behind in the mortgage payment. You can do a modification in the bankruptcy. If you owe homeowners association dues, maybe you can even get rid of the homeowners association dues in the bankruptcy as well. Save your home. If you have more than one mortgage, or you have a mortgage in a line of credit, home equity line of credit, you have a mortgage in homeowners associations dues, you may be able to, again, get rid of, modify those homeowners association dues, pay it back in installment payments, because you may have sufficient income to do so. Again, remember in chapter 13, you need to have income. Okay, so you have sufficient income, you may be able to modify your loan and pay back these debts. But now you're giving the benefit of paying these back over time. You can avoid judgment liens. So that judgment that was entered against you, that they're garnishing your bank account, that judgment became a lien. Remember, I told you it's a lien on your property, and when you try to sell your property, now you're not able to sell it, you have to pay that. Well, in the bankruptcy chapter 13 or chapter 7, you can file a motion and avoid that lien. So now it no longer attaches to your property. Okay. Again, you can modify the mortgage. So this is some of the reasons why someone who has a garnishment or any type of collection activity may decide it's beneficial to file a chapter 13 or to file a chapter 7 or 11, depending on their situation. Okay. A chapter 11, by the way, is filed by someone who has whose debt is over a certain amount. Okay, 1.2 million in debt. They cannot file a chapter 13, they have to file a chapter 11. Okay, so now you've gone through, successfully completed the bankruptcy. Okay, after 90 days, if it's a chapter 7, after 5 years or 3 years, however long the plan was for, you get that fresh start and there's no garnishment, you do not have a debt. Now, when we say here you do not have the debt anymore, it essentially means that you're no longer personally obligated on the debt. So for example, if you have a mortgage, in order to keep your home, you still must make your payments on your mortgage unless you've modified it or unless you've gotten rid of it in a bankruptcy chapter 13 or 11. But you still are required to pay your mortgage. If you do not pay the mortgage, they can foreclose on the property. But once they foreclose on the property, they cannot, and I say they, that's the judgment creditor. If they file a foreclosure action, they are also called the judgment creditor. They cannot pursue you for any deficiency. Okay, so that's what we mean by the debt. It means you still have to pay on those, what we call secure debt, on a house, on a car, but they cannot come after you personally. Okay, but they still need to file a lawsuit. So do not believe they cannot file a lawsuit. They must file a lawsuit still to foreclose on the property. You will be named in the lawsuit, but they cannot try to later garnish your account. So that's another benefit. Again, you filed the chapter 13, it was a debt that existed prior to you filing the bankruptcy. And now they cannot garnish your accounts because you filed bankruptcy, and that was for a debt that existed prior to the filing of the bankruptcy. The good word that we have in bankruptcy is called a discharge. Okay, so if you file bankruptcy, you want to make sure you get a discharge. Okay, that's a good thing in the bankruptcy world. And now you're discharged, you're personally discharged from that debt so that you will not be garnished. No collection activity can continue against you. Bear in mind, garnishment still occurs if you have child support obligations. Okay, domestic support obligations, those things, some federal debts, for example, IRS debt that was not discharged. So there are some debts that are not dischargeable, and garnishment activity will continue, okay? If you have a homeowners association, anything that comes due after the bankruptcy is filed, they can garnish you on those for homeowners association. So if you're in a homeowners association, I would recommend, and I highly recommend, if you're keeping your home, to continue to make your homeowners association payments, because those, anything that comes due after the bankruptcy is filed is subject to garnishment. Okay, and as I mentioned before, we have some helpful resources that's available to you. This is not an exhaustive list of resources, but we have here, for example, the Southern District of Florida, the Bankruptcy Court does have a link on its website for people who do not have a lawyer. So by all means, if you do not have a lawyer and you don't know a lawyer, you don't want to try to contact a lawyer, go to the website, and lots of information on that on the website. On the website as well, it also has a pro bono attorney. So if you need a pro bono attorney, you can fill out the intake form. That form is also with Legal Aid of Palm Beach County. They have it on their website. They have it on the Palm Beach County Bar Association's website as well. The Bankruptcy Court also has free virtual bankruptcy information clinic. That is not a clinic helping you to do bankruptcy, but if you have questions, that's what they're there for, but they're not filing bankruptcy. If you need an attorney and you cannot afford one, you need to fill out the intake form, and that will help you to get an attorney if you qualify. Consumer Financial Protection Bureau, they have a lot of resources there as well, how you can deal with your debts. So it will tell you what you can do, how you can negotiate and try to enter into installment payments. If you are comfortable where you're going to read it and you're going to understand and pursue that type of action on your own, I recommend that you at least educate yourself, okay? So it gives you the best way to negotiate a settlement. The National Consumer Law Center, Surviving Debt, this is going to give you a lot of information as well as to different types of ways to deal with debts as well, including it does give you some more information about bankruptcy as well. So again, these are helpful resources. It's not an exhaustive list, but you have the opportunity to go on these sites, and if you have any financial issues, any lawsuits being filed against you, judgments being entered against you, short of you contacting an attorney, do make these things. These things are available to you to educate yourself. Again, thank you so much on behalf of Legal Aid and our law firm. Thanks for your attendance at today's seminar.